Hello everyone and welcome to Stewarts Soundbites. My name is Nickie Maple-Pearson and I'm an Associate Solicitor at Stewarts. I am your guest host for today as the lovely Emma Lyons is on a well-deserved holiday. But I don't mind as I have the privilege of speaking to Dan Herman, who will be answering some of your questions today. Dan waving. It is not often you get to have a Q&A session with someone like Dan, so thank you to all of those who've sent in their questions. As we're speaking, if anyone thinks of another question they'd like to put to Dan, then please feel free to put it in the Q&A box. And if there's time, then I'm sure Dan will be able to answer it. Dan barely needs an introduction, but for those of you who are not familiar with him, he's a partner in the Leeds office of Stewarts. And importantly, he is head of our Leeds office. He is extremely experienced in the field of catastrophic injury and is described by Chambers as an utterly first-class lawyer, and by the Legal 500 as highly knowledgeable, frighteningly intelligent, and an all-round excellent litigator. I can vouch for all the above and guarantee that your questions are in the very best of hands. So Dan, hello and welcome to Soundbites.
Thanks, Nickie.
I know you've been a guest on Soundbites before, but not in a Q&A format like this. But as always, time is very tight. So without further ado, can I go to my first question?
Fire away.
So the first question that we have been posed is, what do you look for in a case manager, and what aspects of the case management role do you find the most frustrating?
That's the $64,000 question, isn't it? What do we look for in a case manager? I think there's a number of factors that come into play. Some will be more important than others in one case, and others may be more important in another case. So in no particular order, I think geography is important, particularly in circumstances where you've got a client who needs an awful lot of attention and need a lot of hand-holding, where it's more difficult to do that from a distance. I think geography is important for that reason, but also because a case manager who knows the area very well is likely to have more knowledge and more contacts in terms of the therapies that are available, the rehab facilities that are available in that area. Not always, but probably more likely. Second thing is injury-specific experience. At Stewarts, we tend to act for clients who've suffered a spinal cord injury, clients with brain injury, clients with amputations, and there are other types of injuries, but they're the three main sort of categories of injuries that we deal with. And just as lawyers have become increasingly specialised over the years, it seems that case managers have become increasingly specialised. And you might have a case manager from a spinal cord injury background who's worked on one of the specialist spinal injury units in the past and tends to work with clients who've got those sorts of injuries. And equally, you may have people who work with clients with amputations or with serious brain injuries. So injury-specific experience is always really important. Mm-hmm. The kind of intangible fact, which is kind of fit, is this case manager going to fit with that particular client or that client's family, which is equally important. Mm-hmm. And I'm sure, Nickie, you've been involved in cases where you know a really good case manager and you've worked with them before and you know they're fantastic, but you just think this client perhaps needs a slightly different type of approach, slightly different way of being handled, which is why beauty parades are often very important, because you know the client and the family can make play an active part in selecting the case manager and finding someone that they think they can build a rapport with over time. And I think this is true of anyone in any line of work, whether it be a solicitor, a paralegal, a case manager, someone who's a doer, who's got common sense, who's got nous, who is, when giving a list of jobs to do, a to-do list, actually gets them done. Yeah. All too often we're involved in cases, not often actually, but sometimes we're involved in cases where you have a review meeting 3 months after the previous review meeting or 6 months after, and you find that actually not a great deal has happened because things haven't been actioned. Not always the case manager's fault, but sometimes the case manager could have done more. So someone who really rolls their sleeves up and gets stuck in. Yeah. And to answer the second part of your question, what do I find most frustrating? What I find most frustrating is where, despite the good intentions of the case manager and the hard work and graft they're putting in, things don't happen. whether that be because the claimant is being obstructive, and that we all know that can happen, and isn't cooperative, but more often where the insurer is unwilling to provide funds, particularly under the Rehab Code, where they're querying every last penny, asking for alternative costings for every last piece of equipment or every single therapy. And that can be frustrating because it just presents an obstacle, or at least a delay, to the client receiving the rehab they urgently require.
Yeah, absolutely. And I think ultimately that's what we want our clients to recover and to get the rehab that they need, and that's extremely important. So that probably leads on quite nicely to our second question, actually, Dan, which is what are the pros and cons of the Rehab Code versus single instructed case managers to the client, to their case and their rehabilitation?
All things being equal, I tend to prefer a single instruction of the case manager. However, there are issues with that. Obviously, you need interim funds to be able to do that, and interim payments are sometimes tricky to get in the very early stages in a case, because the defendant is quite properly investigating liability and wants to resolve those issues before they release any sums. I can quite understand that. But also there might be cases where even from the very outset, that there are going to be contributory negligence issues in the case, where you know that your client may only recover 50%, maybe even only 25% of the value of their claim. And so you have to think carefully about what's going to be in their best interests. The advantages of the Rehab Code, as we all know, are it's more likely to be available at an early stage in the case, because the defendant can agree to an INA and thereafter fund the recommendations in the INA, notwithstanding any liability inquiries they may have ongoing. May even be available even in very difficult cases where insurers say from the outset, look, we're probably going to deny liability in this case, but we are prepared to fund some rehab. So that's positive. And sometimes that's all the claimant gets out of the case. I was involved in a sad case recently where ultimately it didn't proceed. There wasn't sufficient evidence to prove that his claim was going to be successful, but he had received the benefit of 12 months rehab paid for by the insurer under the INA. So although his case didn't succeed, he did derive some benefit in seeking to pursue a claim in the first place. So they're the positives about the Rehab Code. We all know that, I'm sure, the downsides to the Rehab Code, disputes about who the case manager should even be in the first place. You have the bun fight about that, and then there can be delays in getting approvals for funding from insurers or refusals to fund. And another problem is that it's very difficult to get case managers in conferences, because obviously they owe a duty to both sides, and we can't just pull them into conferences and have discussions with them and the experts and the claimant in the way that we might be able to do so with a singly instructed expert. So there are pros and cons, and it's not black and white. It's all case specific and subject to what's going to be in that particular client's best interests.
Yeah, absolutely. So moving on to our third question, what would be your top 3 tips to prepare and draft a witness statement? Do you always ask for evidence from a case manager, and if so, why? And how important is case management evidence in the litigation process?
Okay, I just wonder, for the case managers that are on here, if anyone wants to click on the raised hand, if they have ever given live evidence at a trial. I'd be interested to know if anyone has.
Absolutely.
Raise their hand or say something in the chat. I suspect not many have, and that's largely because not many cases go to trial on quantum issues. You get cases going to trial on liability, but very, very few cases go to trial on quantum issues. I can't see that anyone's raised their hand.
No, not yet.
So I don't know whether case managers know what actually happens at trial. And I find it, when I tell clients or I tell case managers or any witness in a case what would actually happen, they're often quite shocked. So what would actually happen in practice is that the case manager would be asked to go as a witness, and they swear on the Bible or another holy book, or they make an affirmation, and they'd be asked to turn to tab 16 in the bundle. They'd be asked if that was their witness statement. They'd be asked if that's their signature at the end of it. They'd be asked whether they've had the chance to read it recently, and whether it's still true to the best of their knowledge and belief. Once they've confirmed all that, that's it. That's their evidence. The judge might allow some latitude, might allow some questions about events that have happened since the signing of the witness statement up until the date of the trial, might allow a little bit of leeway to ask a few questions to clarify or amplify on certain points. But broadly speaking, if it's not in the case manager's witness statement, the court will not hear about it.
Yeah.
So when it comes to drafting your witness statement, don't think that, well, I can almost kind of summarize things here and I can amplify on that later at trial. I'll add more to it then. So this is going to be sufficient. If it's not in there, you have to assume that the court's never going to hear about it. And I find that quite instructive. You know, if you have that in mind when you're drafting your witness statement, you may draft it slightly differently, maybe slightly longer, go into more detail than might otherwise be the case. As to why case managers' evidence is important, well, the first thing to say is I can't think of a case that I've conducted in the last 20 years where we haven't taken a statement from the case manager, a singly instructed case manager, that is. And the case manager's evidence can be really, really important. In many cases, the case manager can act as a kind of quasi-expert. You know, the claimant's legal team will have their experts in a whole range of disciplines, and the defendant's team will probably have the same as well. And as we know, there could be a significant dispute between the respective parties' experts as to the diagnosis of the injury, the prognosis of the injury, the level of care that's required, the type of equipment that's required, and so on and so forth. There could be fundamental disagreements about, for example, whether or not the claimant has the capacity, which will have a knock-on effect, certainly in terms of deputyship costs, but also other aspects of the claim as well. But we have to bear in mind that these experts, as brilliant as they are, have only actually seen the claimant for a few hours, maybe a couple of 3 hours in their first appointment, same again for a second appointment, and maybe at best a third appointment with the claimant further down the line. Whereas the case manager has been working with the claimant and the claimant's family, probably by the time he gets to trial, for a period of, 2-3 years at least. Probably been having, if not daily, then weekly contact with the claimant, and has a completely different perspective and probably a greater understanding of the issues the claimant faces day in, day out, particularly when they're not putting their best foot forward, where they're not being brave about their injuries and they're at their lowest ebb. So a case manager, as a kind of quasi-expert, can often be the kind of casting vote if a judge isn't sure about, whose evidence do I prefer, claimant or defendant. If you've got good evidence from a case manager who's worked closely with a claimant, that can be determinative. It really can. So yes, I think it's very important.
Yeah, absolutely. And I think something else possibly is that the case manager is potentially more neutral than the family, I think, in relation to the other statements that might be provided. Yeah.
Plus they've got that professional objectivity. And they're also seeing through from things through the lens of their whether they're an OT or a nurse or whatever they are. They're seeing it in that context rather than as a concerned, sometimes frightened, and not entirely unbiased member of the family.
Yeah, absolutely. So I have one more question. I think we've probably got time for one more.
Okay.
How do you select or instruct your medical experts? What is important to investigate before you instruct? And what information do you ask for prior to instruction? What are your expectations of them during the case?
Wow, that's a big question. I could probably spend half on that alone. Well, it goes without saying that they've got to be genuine experts. I say that, and you might say, well, of course, Dan, to do anything other than that would be ridiculous. But I have been involved in cases where the other party has instructed an expert, when there's serious knee problems, for example, where they're a shoulder orthopedic expert, and you're thinking, well, why are they being asked to comment on this knee issue? So you've got to be genuine experts.
Yeah.
You've got to have a reasonable waiting list. We all know that good experts will have waiting lists, but to wait 15, 18 months for an appointment is tricky.
Yeah,
you've got to be good with the client. We've all heard horror stories of claimants going into appointments and coming out in tears because the expert said something nasty to them. They've got to be good on paper. Their reports have to be really, really good and understandable to the layperson. They've got to be good orally in conference with the experts and being able to explain the rationale behind their opinions. They've got to be accessible in that we can actually get them to conferences, we can get them to court. They've got to be able to turn their reports around within a reasonable period of time, whether that's the report after the appointment or amendments to the report after a conference. And fundamentally, and this is perhaps the single most important thing, they need to be someone that we feel will be persuasive before a judge, because that's what it's all about. We have to plan on the basis that a case is going to trial, and so therefore we need experts who we feel will persuade a judge. So it's not just about the letters after their name or what's on their CV. It's about someone whose style, whose manner, his tone is likely to be persuasive.
Yeah.
So that's the list.
Absolutely, and they're confident in their views that they have put within their report, because the last thing we want is for them to turn around and change their opinion.
Well, I don't mind experts changing their opinion if they come across some new evidence. It's right and proper that they do reconsider things in the light of that, but we don't want people who are just going to turn on a sixpence with no new evidence and contradict what they've previously said.
Yeah, absolutely. Well, we've definitely run out of time, Dan. It does disappear very, very quickly. May I say how grateful I am to you for agreeing to be here today, on behalf of Emma as well, and also for sharing all of your knowledge with the viewers. One point to certainly take away is that you cannot underestimate the importance of case managers and the rehab team to our clients' recovery and ensuring that we're able to achieve the settlement they deserve. If you have any questions about today's episode at all, please feel free to email Dan or I, or find us on Twitter. I'm sure all the information's probably on the links that you've been sent. Thank you to you, the viewers, for tuning in today, and Emma will be back in a fortnight with the next episode of Soundbites. Thanks ever so much.
Bye.
Bye.